How do you know if the defense's settlement offer is appropriate to settle your case? Would you like to know the answer? Come join me for a walk around the lake as I share with you the answer to that question. Hi, I'm Gerry Oginski, a New York medical malpractice and personal injury attorney. You brought a medical malpractice case against careless doctors who you believe caused you significant harm and injury. And now, 2 years later, as your case is approaching trial, the defense finally reaches out to your attorney and says they would like to start negotiating. Now, during the course of the next few days, the defense actually makes a few different offers to your attorney. Your attorney then comes back to you and tells you about those specific offers. How do you know whether any of those offers are right in order for you to settle your case? To answer that question, there are many different factors that have to be evaluated in order to reach the conclusion about whether that offer is or isn't appropriate to settle your case. Now, at the very beginning, before you even start your case, I am sure that once you recognize the extent and the significance of your injuries, you may begin to perceive and have an idea or an understanding in your own mind about the true value of your injuries. You may not be able to work again. You may be so incapacitated that you now require 24-hour nursing care. You may need additional surgeries into the future. You may need ongoing medical care and treatment, including physical therapy. That's going to cost you money out of your own pocket, separate and apart from anything your health insurance might be able to pay. So how do you know exactly how much your pain and suffering is worth? How do you know whether your lost income is sufficient, or at least the offer to replace that lost income is sufficient to cover you, not just for the next couple of years, but for the foreseeable future, and maybe even for the course of your lifetime? How do you know all these things? The reality is that most people don't know. So they have to rely on their attorney to give them an educated answer about the true value of their injuries. So you may have this perception based upon what you read in the papers, based upon what you see online, based upon what your neighbor went through when they had a problem and they brought a lawsuit. And now you know what they settled for. And you know another friend at work who brought a lawsuit and you know what he settled for. And you begin to form in your own mind that your injuries are so much worse than these people that you heard about and these people that you read about. And based upon that information, you've come to the conclusion that your injuries are worth, let's say, $5 million. And you tell your attorney that you will not settle for a dime less than $5 million. Now, by the end of your case, or as you are approaching trial, your attorney will know all the facts of your case. Your attorney will know all the details and all the legal issues, as well as the pitfalls associated with your case. Because you should know this: no matter how great you think your case is, no matter how solid your experts are, there are always going to be pitfalls in every single case, even in the best of cases. So don't think for a second that you have a guaranteed lock to win your case if you go to a jury. Let's say you go to trial and a jury comes back with a very substantial verdict in your favor. The first thing that's going to happen is that the defense is going to ask the court to throw your verdict out. They're going to say it's against the weight of the evidence. And regardless of what the judge does, the defense is going to go ahead and appeal that particular decision as well as that particular verdict. So don't think for a second that just because you may win the legal battle at trial, that you're going to win it in the appellate division. So let's go back to what I said earlier. Your attorney will have to go through and understand and tell you what his perception is of the true value of your injuries. Your attorney, in all likelihood, is going to have done legal research to determine what similar cases to yours have settled for in the county in which you have brought your case. Your attorney likely will also have done research to determine what type of verdicts have occurred in the similar type of case and similar injuries that you suffered, to give him a clear understanding of exactly what your case is worth. Despite your attorney doing this legal research to evaluate what other cases have settled for and other cases have gone to verdict for, there are specific factors in your case that are going to distinguish your case from all the others. Your injuries may not be as bad as someone else who achieved a much greater verdict. Your injuries may be much worse than someone who achieved a settlement and achieved a remarkable settlement. So there are many different things that go into evaluating what is the true value of your injury. Now here's something I find fascinating after doing this now more than 36 years. Each side has the same set of facts when it comes to your injuries. Each side knows exactly what your medical injuries are. Each side has the same medical records. And they know what limitations and disabilities and things you can and cannot do. Everybody knows that. We're all on the same page about the knowledge associated with those things you can or can't do or are limited from doing on a daily basis. So you might ask yourself, if both sides know this information and both sides are on the same playbook in terms of what your injuries are, why are there so dramatic differences between what the defense thinks your case is worth and what you and your attorney think your case is worth? And that's one of the inherent problems associated with our legal system in New York. There are always going to be disputes about the value of your injuries. So let's say that the defense acknowledges that their doctors did something wrong and caused you harm and injury. And now what they contest is the value of your injuries. They will always argue that the value of your injuries are much less than you claim, and that you're not as disabled and limited from doing your activities as you perceive them or as you claim to be. And that creates a conflict along with uncertainties, because the defense knows that if they go to trial, a jury may go ahead and recognize those injuries that you are claiming, and may compensate you substantially based upon those injuries, knowing full well that they were definitively caused by the doctors and the hospital staff. On the other hand, the defense may appeal to the jury's sense of logic and turn around and argue that your injuries are nowhere near as bad as you claim them to be. And they may recognize that there's a problem, and the jury may compromise their verdict. And so even though you may not want to settle for less than $5 million, if you go to trial, a jury could come back and say, you know what, your injuries are only worth $1 or $2 million. And now you've got a problem, because here you might have been offered a lot more than that to settle, but you refused, believing that your case was worth $5 million. And now you'll have to go through the appellate level to see if you can overturn the jury's verdict and get a new trial on damages to increase the value of your injuries. Now, on the other hand, the jury could come back and give you a huge, huge amount of money as full and fair compensation for all of the harms and losses and damages that you incurred. And that's great for you, but it's not going to help you in the long run, maybe. Why? Because now the defense is going to appeal. And that could take another 1 to 2 years. So let's go back to the question that I raised at the beginning. How do you know what the true value of your injuries are? And how do you know whether the offer, the settlement offer, is right for you? There's going to be a question that you're going to have to answer, which is, let's say the defense makes a very substantial offer, and now you have no interest or desire to have your case tried. You don't want to spend 3 weeks trying your case in court and have to take time out of your life to go ahead and come into court every single day, listen to testimony, get upset, get aggravated, get angry when listening to opposing testimony. And now, is it worth it for you to take a lower number based upon the convenience of not having to go through 3 weeks, 4 weeks, 5 weeks worth of trial? Only you can answer that question. And with your attorney, you'll be able to go ahead and assess, hopefully, what the true value of your injuries are. And maybe the number that you had at the very beginning and as your case progressed about what you believe your injuries are truly worth, maybe that will evolve over time. Maybe you think your case is worth much more now because of this ongoing permanent disability. And you have every right to believe that. However, the reality may be a little bit different. So why do I share this quick information with you? I share it with you just to open your eyes and help you understand how these types of cases work in the state of New York. There is no clear-cut answer to the question that I raised at the beginning of this video. There's so many factors that have to be taken into account in order for you to determine whether the defense's settlement offer is right for you and whether or not you can live with that offer, recognizing that it may be different than what you originally believed your case was worth, and importantly, recognizing that out of any settlement offer, there's going to be the attorney's fee that is taken out of that number, as well as the attorney's expenses. There may be another entity like Medicare or Medicaid that turns around and says, hey, we paid for all of your medical expenses relating to this wrongdoing and the treatment you received. So therefore, we are now demanding that you repay us that money. That's called a lien. And now that has to be negotiated and repaid back to them. In that instance, that settlement offer, which your attorney tells you may be the appropriate number for you, now you have to ask the key question. Okay, after the expenses, after the attorney's fee, after any lien is repaid, what do I walk away with? And maybe once you get that answer, you can come to the conclusion about whether or not that settlement offer is right for you. Want more information about how these cases work in the state of New York? Well, if you have not yet started a lawsuit, but are thinking of doing so, and your case happened in New York, and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207, or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.